Hello everyone. This is a video in which we will be covering Chapter 7, 8 and 9 of the Arbitration and Conciliation Act. Now that we have understood as to how the arbitral tribunal is to be appointed, and once the arbitral tribunal is appointed, how the proceedings are to be commenced and conducted as per Chapter 5 of the Act, and after the conduct of the arbitral proceedings, the award is to be made and the proceedings are to be terminated in accordance with Chapter 6 of the Act. Now, once we have an arbitral award, the next question that arises is that can any party challenge such an award? The answer to this question is given in Chapter 7 of the Act, which deals with the provision pertaining to recourse against arbitral award. So yes, a challenge against an arbitral award is maintainable on the specific grounds mentioned under Section 34. Now, Section 34 is a detailed section which does to quite an extent give us all the answers to our questions, whether it is the forum before which the recourse can be made, or the grounds with respect to on the basis of which an arbitral award can be challenged, or the limitation period within which the challenge needs to be made, right? So Section 34 is a detailed section which gives answers to all these questions. So we will address them one by one. So when we're talking about recourse against an arbitral award, the first question that needs to be addressed is, where can the recourse be made? Where will the parties go to? Which will be the forum where the parties will be required to um, file for an application for setting aside the arbitral award? Second essential question to be determined is, what are the grounds on the basis of which an arbitral award can be challenged? And the third important question is, within how much time can the challenge be made against an arbitral award? Because we do understand that in keeping with the requirement of an expeditious disposal, an expeditious enforcement also needs to be taken care of. So all these questions we'll be addressing one by one. The first question is, which is the forum? Where is the application for setting aside an arbitral award is to be made, right? Now, Section 34 under subsection 1 makes it clear that an application for setting aside an arbitral award is to be made before a court. The exact language used in Section 34 subsection 1 is, recourse to a court against an award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Now, as far as the concept of court is concerned, since Section 34 talks about the forum to be a court where an application for setting aside the arbitral award is to be made. Now, which court are we referring to here? Now, as far as the expression court is concerned, it's defined in Section 2E of the Act. Now, 2E says court means in the case of an arbitration other than international commercial arbitration, the principal court of original jurisdiction in a district, right, which will be the district court, and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. So that would be in the case of an arbitration other than international commercial arbitration, which we're talking about domestic arbitration. But in case of international commercial arbitration, what would court mean? It would mean the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit. And in other cases, a High Court having jurisdiction to hear appeals from decrees of court subordinate to that High Court. So basically, in case of domestic arbitration, it would be a district court, and in case of international commercial arbitration, it would be a High Court, But in case of domestic arbitration as well, if the pecuniary jurisdiction is limited of that particular district court, then it would go, the application under Section 34 would go to the High Court concerned. Now, once we are clear about the forum before which the application is to be filed, the next question, I've been referring it to it time and again, that the type of proceeding that is to be filed is an application for setting aside an arbitral award. So we do not call this an appeal because we're not opening the merits of the case. It is only an application which is limited to the specific grounds mentioned under Section 34. Now let's proceed further to the grounds on which an arbitral award can be challenged. Now, Section 34, subsection 2 and subsection 2A specify the grounds on the basis of which an arbitral award can be challenged. Now, the grounds under Section 34 are under subsection 2 are divided into two parts. The first part dealing with clause A of subsection 2, which provides that the applicant who is making the application under Section 34 has to establish on the basis of the record of the arbitral tribunal the first 5 grounds mentioned here. The first 5 grounds mentioned here need to be established under clause A by the applicant on the basis of the record of the arbitral tribunal. The next 2 grounds are provided under clause B, where the court finds that these grounds exist which warrant an interference, which warrant that the arbitral award should be set aside. Now, if these grounds exist, then in that case, it would be a ground for setting aside the arbitral award. Now, in addition to these grounds mentioned under clause A and clause B of subsection 2, subsection 2A, which was inserted by the 2015 amendment, also provides for another ground. And then we have further 2 more grounds which are specifically not mentioned in 34, but by virtue of provisions contained in section 13 subsection 5 and section 16 subsection 6. These are included within the grounds. So let's see one by one. Let's see for ourselves what these grounds are. Now, the first ground of challenge to an arbitral award would be that a party was incapable of entering into a contract or was not properly represented. So we understand that the Indian Contract Act provides for certain requirements of the parties to enter into a contract. For example, a minor is incapable of entering into a contract. A person of unsound mind is incapable of entering into a contract. But in case the person is represented by a guardian, so if a guardian has been appointed, then this ground of incapacity cannot be alleged in an application under section 34. It can be, but not successfully alleged, right? Now, incapacity of a party is the first ground on the basis of which an arbitral award can be challenged. So once it is established that a party was incapable and was under an incapacity, then in that case, it would be a ground for setting aside that arbitral award. The second ground is of invalidity of the arbitration agreement. Now, subclause 2 of clause A of subsection 2 of section 34 provides the arbitration agreement is not valid under the law to which the parties have subjected it or failing any indication thereon under the law for the time being in force. So the parties if the parties have subjected the agreement to a specific law, then it needs to be valid under that specific law, or if that indication is not there, if that specification is not there, then under the law for the time being in force. So an invalid arbitration agreement, if the very essence or the very source of the arbitral proceedings, which in fact is the arbitration agreement, is in itself invalid, then an award passed as a result of the same would also be um, an invalidity and is liable to be declared as such by the court under section 34. The third ground talks about, subclause 3 talks about, the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. So want of notice की यहाँ पे बात हो रही है. Want of notice on the applicant. So the applicant was not given notice of the appointment or of the proceedings, or unable to present its case. So in keeping with the requirements of natural justice, the principle of natural justice, to ensure that each party is given a chance to represent itself, so proper notice needs to be given to both the parties, whether of appointment of arbitrators or of the conduct of the arbitral proceedings, and the parties have to be given the chance to present themselves. So if there is a fault on any of these counts, then in that case the ground given under subclause 3 will apply if there is a want of notice, which of course will have to be established by the applicant on the basis of the record of the arbitral tribunal. Next is award deals with the dispute outside the scope of reference. So when the award deals with a dispute which is not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration. So the submission that has been made, the reference that has been made to arbitration, the award deals with a matter which is outside the same, right? So we can take the example of, say, for example, there are two matters, A and B, which have been referred to arbitration. There are claims made with respect to C as well during the arbitral proceedings, and the award is passed with respect to all these three issues. Now, the fact that C was outside the scope of reference would attract clause 4, subclause 4, right? But if the matters as pertaining to C can be separated from the matter pertaining to A and B, then only C would be set aside, only the award to the extent of the issue dealt with respect to C would be set aside, and B would still remain valid in accordance with the proviso to subclause 4. Please make sure that you read the bare provision along with when we are watching this video. The fifth subclause under clause A is improper composition of the arbitral tribunal. So we do understand that the arbitral tribunal is to be constituted in accordance with the arbitration agreement. If the arbitration agreement stipulates a procedure for the appointment of arbitrators, then the same has to be followed. And if it does not specify, then in accordance with the law. So subclause 5 says the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, unless such agreement was in conflict with the provision of this part from which the parties cannot derogate, or failing such agreement was not in accordance with this part. So the arbitration agreement, if it provides for the composition of the arbitral tribunal, it is to be adhered to unless it is in contravention of any of the provisions of this part, which of course they cannot derogate from. Otherwise, तो हम जानते हैं कि mostly provisions contained in the Arbitration and Conciliation Act provide for use this expression unless otherwise agreed between the parties, which means that party autonomy is given precedence over the provisions of the Act, and the provisions of the Act would apply in case of the absence of any agreement between the parties. Now, these are the first 5 grounds given under Clause A. The next ground is of inarbitrable disputes, which is provided under Clause B, Subclause 1. The language used by Subclause 1 is, the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force. So we understand that not all disputes are arbitrable. There are certain disputes which are kept out of the purview of arbitration for certain reasons. For example, we understand that criminal matters are inarbitrable, testamentary matters are inarbitrable, matrimonial matters are inarbitrable. Now, the Supreme Court, in the case of Booz Allen and Hamilton Incorporated versus SBI Home Finance Limited, the Honorable Supreme Court in this judgment has clarified that as a general rule, all the matters which would be amenable to the jurisdiction of a civil court would be arbitrable. But there are certain matters which have been kept out of the purview of arbitration, specifically in accordance with this judgment, including criminal matters which are outside the jurisdiction, which would not be arbitrable, and testamentary matters, winding up matters, matrimonial matters. So there are certain matters which have been kept exclusively out of the purview of arbitration in order to ensure that the specific matters are not dealt with by arbitration due to certain specific reasons, right? Now, in addition to these grounds, eviction or tenancy matters also have been in accordance with the Booz, Allen and Hamilton judgment. Eviction or tenancy matters have also been kept out of the purview of arbitrable disputes. Guardianship matters, insolvency, winding up, we've just discussed. So this judgment in the year 2011 has clarified the position to quite some extent. In addition to this judgment, there's another judgment which is A. Ayyaswamy versus A. Paramasivam. The name of the judgment is A. Ayyaswamy versus A. Paramasivam. This is 2016 judgment of the Honorable Supreme Court. The citation being 2016, volume 10, SEC 386. Now, the Honorable Supreme Court in this judgment has held that certain kinds of disputes may not be capable of adjudication through the means of arbitration. So, certain disputes like criminal offences of a public nature, disputes arising out of illegal agreements, and disputes relating to status such as divorce cannot be referred to arbitration. There have been specific categories of disputes which have been laid out in this specific judgment, which are inarbitrable disputes, and hence if they fall within the category of inarbitrable disputes as declared by the Honorable Supreme Court, then it would be a case which would fall under subclause 1 of clause B of subsection 2 and hence be liable to be set aside. What are those matters as in accordance with the judgment in Ayyaswamy versus Paramasivam? First is patent, trademarks and copyrights. Second, competition laws. Third, insolvency or winding up matters. 4, bribery or corruption matters. 5, fraud. 6, criminal matters. Now, as far as the concept of fraud is concerned, the Supreme Court in this very judgment sought to clear the muddied waters surrounding the arbitrability of issues relating to fraud. So the court has held that although mere allegations of fraud simpliciter are arbitrable, but serious allegations of fraud are not. So this is the law as far as inarbitrable disputes are concerned. The next question is with respect to the next subclause, which is award being in conflict with public policy of India. Now, I have laid a lot of emphasis on this specific aspect because this is one aspect which leaves a lot of room for interpretation, this ground. So we will be discussing this at length in the next part of this video. The next is award was vitiated by patent illegality appearing on the face of the award. Now, this is a change which has been introduced by the Amendment Act of 2015, wherein the court the legislature has added this ground to the already existing grounds with respect to the setting aside of the arbitral award. Now, award vitiated by patent illegality on the face of the award. With respect to this, the exact provision is that an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Now, this can be discussed in a better way once we discuss the concept of public policy, right? So we will be discussing the concept of public policy first and then covering this matter. And lastly, for reasons stated in section 13 subsection 5 and section 16 subsection 6. Now section 13 subsection 5 talks about the challenge to the appointment of an arbitral tribunal. So when any party wishes to challenge the appointment of an arbitral tribunal, then there are certain specific grounds on the basis of which that challenge can be made. Now, those grounds are mentioned in section 12 of the Act. Section 12 lays down that primarily there are two grounds on the basis of which the appointment of the arbitrators can be challenged. Now, the first ground is with respect to the independence or impartiality of the arbitrator concerned. So, if there are justifiable doubts as to the independence or impartiality of the arbitrator concerned, then in that case, this would be one of the grounds. And secondly, if the appointment has, if the arbitrator does not fulfill the qualifications prescribed by the arbitration agreement between the parties. So in that case, if either of the grounds exist, either of the parties to the arbitral proceedings may file for an application for challenging the appointment of the arbitrator before the arbitral tribunal itself. Now, as a result of such an application, there are two consequences that would follow. One would be that the arbitrator accepts the challenge and steps down as such. The other would be that the challenge to the appointment of the arbitrator is rejected by the arbitral tribunal. In the case of rejection of such a challenge, the law says under section 35 subsection 5 that the party aggrieved by such a rejection may file for setting aside of the award which is passed as a result of the arbitral proceedings conducted after the rejection and the award passed thereby. Right? So this is the first ground, which is by an inference we are adding here because it is not specifically mentioned in section 34, but because section 13 subsection 5 gives a reference to the same, hence we are including it here. Further, Section 16 subsection 6 also talks about another instance जिसमें कि uh, the challenge is to the arbitral tribunal itself, but not to the appointment, but to the jurisdiction of the arbitral tribunal. When a challenge to the jurisdiction of the arbitral tribunal, whether it is challenge as to the lack of jurisdiction or to the excess of jurisdiction, uh, then again, if the arbitral tribunal rejects such a challenge, then the party aggrieved by such a rejection may file under Section 34 for setting aside an arbitral award which is passed after such a rejection, after conducting arbitral proceedings and an award passed thereafter. That award may be challenged by the aggrieved party before uh, the court under Section 34. Now, these are primarily the grounds on the basis of which an arbitral award can be challenged. Now, we'll come to this later. First, let's discuss the head of public policy, which is open to a lot of interpretation because of the subjective nature of the expression used, right? Now, it's interesting to note that public policy being one expression which, of course, has been used in the Arbitration Act under Section 34. But over the years, its interpretation has been interesting to note, where starting from the Renu Sagar judgment in 1994 to the latest judgment of Patel Engineering, the Honorable Supreme Court has time and again tried to interpret this expression, and let's see how the judicial approach has been over the years. Now, as far as the expression public policy is concerned, it was once stated by Justice Burrow that it is an unruly horse, and once you get astride it, you never know where it will carry you. So this is an expression, this is the kind of an interpretation which is given by a legal luminary like Justice Burrow, who, while defining the concept of public policy, taking it to be an arduous task. The definition of the concept of public policy is quite an arduous task. So, considering it as such, he has observed that it can be related to an unruly horse. And of course, the Indian courts also have dubbed it as an unruly horse, thus giving it the impression that it can never be defined. However, uh, the, the judiciary has attempted to give a structure to the concept of public policy with respect to setting aside of arbitral awards. So, in this regard, it is necessary, in my opinion, that we analyze the Supreme Court's decisions which have been given from time to time. Starting with the Renu Sagar Power Company Limited versus General Electric Company. This is the first judgment. Renu Sagar Power Company Limited versus General Electric Company. Now, this was one of the earliest of the Supreme Court judgments to consider the concept of public policy. Now, in this decision, the Supreme Court held that an award which violates the Foreign Exchange Regulation Act, being a statute which was enacted to safeguard national economic interests, will contravene the public policy of India. And thus, the fundamental policy of Indian law will be violated as such. So, in this specific judgment, the court says that ऐसी statute जैसे कि फेरा की statute है, फॉरेन एक्सचेंज रेगुलेशन एक्ट है, अगर कोई स्पेसिफिक अवार्ड जो है वो उसकी प्रोविजंस को वायलेट करता है, and FERA being one of the statutes that has been enacted to safeguard the national economic interest, in the opinion of the Supreme Court, this would be a ground which would fall within the purview of public policy, within the purview of contravening public policy of India, and hence be liable to be set aside. Now, the Honorable Supreme Court limited the scope of public policy to three grounds under this judgment. It talks about fundamental policy of Indian law. Second is interest of India, and third is justice or morality. So, as per the Honorable Supreme Court in Renu Sagar Power Company Limited versus General Electric Company, the Honorable Supreme Court tried to limit the scope of the expression public policy to basically three grounds. So, if an award is in violation of either fundamental policy of Indian law, secondly, interests of India, or thirdly, justice or morality, then in that case, that would fall within the purview of the expression public policy as used in subclause 2 of clause B of subsection 2 of section 34. Now, thereafter, there was another judgment, important judgment of ONGC versus saw pipes. This is again a very important landmark judgment of the Honorable Supreme Court, ONGC versus Saw Pipes Limited, which is a judgment of 2003. After 1994, we come to 2003, wherein the Saw Pipes judgment stated the term public policy should be understood in a wider context and includes the concept of patent illegality. तो बेटा आज के टाइम में जो हम सबसेक्शन 2A में एक्सप्रेशन पेटेंट इलीगैलिटी पढ़ते हैं ना, I'll take you back to that expression. Patent illegality, which is now an expression and used under one of the grounds for challenging the arbitral award, सबसेक्शन 2A में, जो कि 2015 की अमेंडमेंट से इंट्रोड्यूस करा गया था, वो पहली बार ONGC वर्सेस सॉ पाइप्स में ऑनरेबल सुप्रीम कोर्ट ने यूज किया था. ठीक है, तो ऑनरेबल सुप्रीम कोर्ट ने यहाँ पे तो नैरो इंटरप्रिटेशन देते हुए इन रेणु सागर इसको 3 हेड्स में डिवाइड कर दिया. अब यहाँ पे ONGC में कोर्ट ने थोड़ा went a little step further and gave it a wider context and held that it includes concept of patent illegality also. Now, did the court explain patent illegality? Yes, it did. In ONGC versus saw pipes, court says that patent illegality means any error of law on the face of an award. Now, the judgment also held that an award can be set aside if it is so unfair and unreasonable that that it shocks the conscience of the court. So, in addition to the grounds mentioned in Renu Sagar's judgment, the Honorable Supreme Court in ONGC versus saw pipes has given it a wider connotation and held that the award can be set aside if it is A, contrary to public policy of Indian law, B, contrary to interest of India, C, contrary to justice or morality, or is patently illegal, or it is so unfair or unreasonable that it shocks the conscience of the court. So these are the 5 grounds which have been mentioned under ONGC versus saw pipes. तो 5 grounds इसका मतलब कि उसको जो interpretation है बहुत ज़्यादा wide दी गई थी by virtue of the ONGC versus saw pipes judgment. Now, on the one hand, the law set out by the Supreme Court in saw pipes led many other courts to include any error of law within the scope of Section 34, including subsequent decisions of the Honorable Supreme Court. Thus, इसके बाद क्या हुआ, क्योंकि वाइड इंटरप्रिटेशन जब भी किसी एक्सप्रेशन को दी जाती है उसमें क्या होता है कि it leads to a lot of litigation happening after that. It opens the floodgates for litigation, right? Which is what happened after the saw pipes judgment, right? So now next needs to be seen what was the stance of the court in 2006. Now, 2006, McDermott International Incorporated versus Byrne Standard Company Limited. In the year 2006, the court expressly noted that until a larger bench reconsidered the correctness of saw pipes, it was bound by the decision, right? So, since this under saw pipes, the wide interpretation which is given by the court had to be now interfered with. It needed interference because it had opened the floodgates of litigation. So, it was held that there needs to be a larger bench that decides, right? So in saw pipes, the Supreme Court widened the scope of public policy As such, the judgment was considered more of a step backwards rather than a step forwards, right? As it allowed for greater judicial interference in arbitral awards and frustrated one of the objectives of the Act, which of course was discouraging interference in arbitral awards. So at this stage, Indian law with regard to setting aside an arbitral award on the basis of the public policy was indeed proving to be an unruly horse. Now, there was a report of the Law Commission in the year, the 246th report of the Law Commission in the year 2014. And in this specific in this specific report, to deal with the jurisdictional expansion of the concept of public policy, Law Commission provided a narrow interpretation of the term public policy. It suggested substantial amendments to Section 34 of the 1996 Act in an attempt to ensure that the Renu Sagar position applied to all foreign awards and all awards passed in international commercial arbitration. So with respect to domestic arbitration, the Law Commission recommended that the patent illegality test be retained but construed more narrowly than under sawpipes regime. Right? So ये तो था जो recommendations Law Commission ने दी under its 246th report. So Law Commission's 246th report suggested amendments to the Act with the aim of ensuring that terms such as fundamental policy of Indian law, conflict with basic notions of morality or justice were to be construed narrowly. राइट वो जो एक्सप्रेशंस पहले दोनों जजमेंट्स में यूज करे गए हैं उनकी जो इंटरप्रिटेशन है उनको नैरो इंटरप्रिटेशन देनी है, वाइड इंटरप्रिटेशन नहीं देनी है, ताकि ऐसे ना हो कि इट ओपन्स ऑल अवार्ड्स टू अ चैलेंज ऑन द बेसिस ऑफ पब्लिक पॉलिसी. उसके बाद जो इम्पोर्टेंट जजमेंट आई वो 2014 में थी, ONGC वर्सेस वेस्टर्न गीको. Western Gecko judgment of the Honorable Supreme Court in September 2014, 1 month after the publication of the Law Commission's 246th report, a 3-judge bench of the Supreme Court interpreted which expression? Fundamental policy of Indian law, जो कि first head था of public policy as stated in Renu Sagar's judgment. Right? Let me just bring you back to Renu Sagar's judgment. Fundamental policy of Indian law was the first head. Second was interest of India. Third was justice and morality. तो ये जो 3 heads हैं ये अंडर रेणु सागर प्रोवाइडेड थे और ONGC में इनमें 2 और heads ऐड कर दिए गए जो कि पेटेंट इलीगैलिटी थी and it is so unreasonable or unjust that it shocks the conscience of the court. तो 5 heads ONGC के अंडर ऐड करे गए और 3 heads यहाँ पे. तो in ONGC versus Western Gecko, the Supreme Court was dealing with this first head of the Renu Sagar judgment, first head of public policy as provided by the Renu Sagar judgment. As per the Supreme Court, an award, the interpretation given by the Honorable Supreme Court with respect to fundamental policy of Indian law was to include perversity and irrationality. Court ने कहा कि उसको it should be so perverse and irrational that it would be opposing fundamental policy of Indian law. As per the Supreme Court, an award could therefore be set aside if it was perverse or irrational, or if the arbitrators came to a finding at which no reasonable person would have arrived. So this is the judgment of ONGC versus Western Gecko. The perversity of irrationality of the decision was to be treated on the touchstone of the Wednesbury principle of reasonableness. So this is the judgment in ONGC, and in a way, what was the effect of the judgment? The ONGC judgment permitted the courts to review arbitral awards on their merits on the basis that they violated public policy and expanded the court's powers under Section 34 rather than minimizing them. ये था असर ONGC की judgment का, क्योंकि perverse and irrational जब हम assessment करते हैं तो वो it would rather widen the scope of interference by the courts. Now, next is Associate Builders versus Delhi Development Authority, which is a 2015 judgment of the Honorable Supreme Court, 1 year after ONGC. Associate Builders versus DDA. Now, ONGC was followed by Associate Builders, number one, in which the Supreme Court, among other things, held that the merits of an award can be examined only under the broad umbrella of public policy. The Supreme Court relied on landmark judgments such as Renu Sagar, Saw Pipes, McDermott International, and ONGC and set out what would constitute fundamental policy of India. So, ये जो again first head of Renu Sagar था, fundamental policy of Indian law, उसमें क्या क्या included होगा? The Supreme Court held that this term includes factors such as disregarding orders of superior courts. अगर कोई सुपीरियर कोर्ट्स के कोई ऑर्डर्स हैं उनके डिसरिगार्ड में आप एक अवार्ड पास कर रहे हो, that would be against the fundamental policy of Indian law. Secondly, judicial approach, quite the same thing. Which is the antithesis to arbitrary approach, and principles of natural justice. अगर natural justice जो है वो नहीं comply किया गया. So, as per the Associate Builders versus DDA Development Authority, fundamental policy of Indian law would include disregarding, contrary to fundamental policy of Indian law, would include an award which disregards orders of superior courts, which disregards judicial approach, and which does not adhere to the principles of natural justice. Further, जो perversity वाला ground लिया था ONGC में, with reference to the ground of perversity, the Supreme Court held that an award will be perverse if it is based on no evidence. So perversity is from the point of view of evidence. If it is based on no evidence, the arbitral tribunal took into account something irrelevant to the decision at which it arrived, or the arbitral tribunal ignored vital evidence in arriving at its decision. So this is with respect to perversity, the ruling as given in Associate Builders. Now, this ruling marked a significant step forward for the prior amendment regime and led to the numerous pro-arbitration decisions of the Supreme Court in recent years. However, यहाँ पे हमें note करना जरूरी है that the judgment did leave some room to set aside awards in limited cases where factual errors reflected that the arbitrator's approach was arbitrary and thus patently illegal. Now, in the aftermath of these judgments, the supplement to 246th report of Law Commission was brought out. So the Law Commission considered the negative consequences of ONGC and Associate Builders. Now, what were the negative consequences? The further erosion of faith in arbitration proceedings among individuals and businesses. There was a reduction in India's popularity as a destination for commercial arbitration. There was increased investor concern amongst domestic as well as foreign investors as to the efficacy and speed of dispute resolution mechanism provided by our Indian law, and of course the potential for judicial interference. And there was an incidental increase in the judicial backlog. So which was felt by the Law Commission that there needs to be a supplement that needs to be brought out, and hence on 6th of February 2015, the Law Commission issued a supplementary report reiterating the recommendations made in which report? In the 246th report. ये जो पहले वाली report थी, उसकी जो recommendations थी उनको reiterate किया and clarified what constitutes fundamental policy of Indian law. Now, as a result of this report, the Arbitration and Conciliation Amendment Act was passed and significantly amended the 1996 Act, which is based on the Law Commission's reports, right? In order to reduce the court's intervention in arbitration. So in particular, the 2015 amendment introduced certain amendments which narrowed the scope for setting aside the awards. In particular, the scope of public policy as provided for in section 34 has in fact been narrowed so that awards can be set aside only if, अब आप देखो, I'll draw your attention to the provision contained in subclause 2 of clause B, explanation 1. Explanation 1 says, for the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if 1. The making of the award was induced or affected by fraud or corruption or was in violation of section 75 or 81, or 2. It is in contravention with the fundamental policy of Indian law, or 3. It is in conflict with the most basic notions of morality or justice. Now, this way, the Amendment Act, which has added this explanation 1, has sought to narrow the concept of public policy by limiting it to these three heads only. Please pay attention to this. Further, a new section 22A was introduced, which states that an award may be set aside if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Right? So in terms of this amended provision, we need to understand, beta, that an award cannot be set aside merely on the ground of erroneous application of the law or reappreciation of evidence. Right? Therefore, the amendment clearly demonstrates the legislature's intention for the public policy exception to be interpreted restrictively. So legislature की जो intention है कि भाई ये narrow interpretation होनी चाहिए, इतनी wide interpretation नहीं होनी चाहिए कि it opens the floodgates for litigation. Hence, it has sought to clarify that point. Now, 2015 की तो amendment आ गई इस stage पे, but what happened in the 2015 post 2015 era? We need to assess that as well. So the first judgment, which is of relevance here, is of Sangyong Engineering and Construction Company versus National Highways Authority of India. Now, the Supreme Court's decision in this case led to some notable developments. The judgment sums up the position following the 2015 amendment. Now, according to the court, the interpretation of the term public policy was narrowed by the 2015 amendment, that we understand, and the amendments to section 34 of the Act, especially the removal of the wide interpretation of the term, were substantive in nature. Therefore, the post-amendment position does not apply to applications relating to section 34, which were instituted before the 2015 amendment, unless otherwise agreed by the parties. So, वो applications जो कि 2015 amendment से पहले institute करी गई थी, उनको पहले वाली ही provision जो है वो apply करेगी. Now, public policy of India now means the fundamental policy of Indian law, as explained in Associate Builders, which of course was taken from the Renu Sagar judgment. This means that the law set out in ONGC no longer applies. However, principles of natural justice remain grounds on the basis of which an award can be challenged. So that is of course taken from the Associate Builders judgment. So the public policy of India is now constricted to mean that a domestic award must be contrary to the fundamental policy of Indian law or against the basic notions of justice or morality, right? And of course, the fact that it was vitiated by fraud or corruption. Insofar as domestic awards are concerned, an additional ground is now available under section 2A, which was added by the Amendment Act, which we will just be taking up. Now, the Supreme Court has, in all these judgments, tried to clarify the stance. But again, there was another judgment after the Sangyong judgment. The Sangyong judgment threw much needed light on the legal position regarding the setting aside of arbitral awards. But in its recent judgment in Southeast Asia Marine Engineering and Construction Company versus Oil India Limited, which is a 2020 judgment of the Honorable Supreme Court, the Honorable Supreme Court has set aside the award in question on the ground that the tribunal's interpretation of a contractual provision was not reasonably possible on reading the contract as a whole. Now, this judgment dealt with the pre-2015 amendment situation, and while acknowledging the limited scope of Section 34, somewhat dealt with the merits of the case as well. In the later judgment, which is the last judgment, which is again a judgment of 2020, but which came after Southeast Asia, which is Patel Engineering versus Northeastern Electric Power Corporation Limited. A three-judge bench of the Honorable Supreme Court dealt extensively with the history of patent illegality as a ground for setting aside a domestic award. So, dealing with the position post 2015 and the latest judgments in this respect, including Sangyong, including Associate Builders, जो इससे पहले की judgments आई हैं. The Supreme Court in Patel Engineering noted that the ground of patent illegality is available to set aside a domestic award if the arbitrators A. Decision is found to be perverse or so irrational that no reasonable person would have arrived at that decision, or B. Construction of the contract is such that no fair or reasonable person would have made that the same construction, or the arbitrator's view is impossible. Therefore, Patel Engineering mein beta, it essentially reaffirmed the view that an arbitral award can be set aside under Section 34 if it is patently illegal or perverse. So this is the way the Honorable Supreme Court has interpreted the expression public policy and where it has come to today, starting from the Renu Sagar's judgment to Patel Engineering in 2020. So, in my opinion, the stakeholders are undoubtedly propagating a regime under which there is less court interference with respect to setting aside an award, which should see arbitrate and not litigate become the norm, right? So the norm that we're trying to put across is arbitrate and not litigate. So, but at the same time, the arbitration's main objective is to ensure the delivery of a legitimate award in the interest of justice, which is why the law permits the courts to interfere in arbitral proceedings, right? In certain specific cases. Further, the court's hearing of Section 34 applications should not be reduced to mere endorsement, right, which shies away from interference. So, in my opinion, a balanced approach is required by the courts to achieve the true objective of the 1996 Act. Now, let's come back to Section 34. The third question that needs to be identified is within how much time can an application be filed under Section 34? So Section 34 prescribes a time limit, which is a time limit of 3 months. A time limit of 3 months is prescribed for making an application under Section 34 for setting aside an arbitral award. But from which date? From the date on which the applicant received the award. So from the date on which the applicant received the award, or if a request was made under Section 33. Section 33 के अंदर कौन सी request करी जा सकती है for correction and interpretation of the award, right? So if a request had been made, then from the date on which that request had been disposed of. So in either of the situations, if a request under 33 is not made, then as and when the applicant received the award, from the date of such receipt to a period of 3 months is the time period within which an award may be challenged, right? But there can be situations we understand which might warrant an interference by the courts, which might warrant an interference by the courts on justifiable grounds, even beyond a period of 3 months, right? So the law under subsection 3 says that if the court is satisfied that the applicant was prevented by sufficient cause from making the application, within the said period of 3 months, it may entertain the application within a further period of 30 days, but not thereafter. Okay. So condonation can be done by the court, but the court can condone only up to a further period of 30 days. Please note that yes, we have the Limitation Act in place, which is a general law. But in view of the fact that this is a special law prescribing for a specific limitation period, this special law would apply because of the use of the expression but not thereafter. Please note that in proviso to subsection 3, it is written expressly but not thereafter, which means that any time if prescribed by the Limitation Act in addition to this time would not apply. How in such a case, the special law as contained in section 34 subsection 3 would only apply. Hence, the maximum time period within which an award can be challenged at the most is 4 months. How it is 4 months? 3 months plus 30 days, up to a period of 30 days, which the court may condone if a justifiable reason is proved before the court, right? Now, before we come to the next topic, we also need to assess as to further provisions which are incorporated in subsection 4. Subsection 4 एक बहुत ही important provision है. It talks. I'll first read this provision for you. It says, on receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as the opinion of the arbitral tribunal, will eliminate the grounds for setting aside the arbitral award. So this is what subsection 4 of section 34 talks about. Now, when an application for setting aside an arbitral award has been made, we need to understand that the court may, instead of adjudicating upon the grounds raised, adjourn the proceedings for a determined period of time to enable the tribunal to deal with the grounds on which the objections have been raised and to eliminate them, right? Now, this can be done when the court considers it appropriate and a party makes a request. ये बहुत essential है for us to understand that it is only upon a request made by the party, and if the court finds it appropriate, it will adjourn the proceedings. Now, upon such adjournment, the arbitral tribunal shall resume the arbitral proceedings and take such action as will eliminate the grounds of the same, right? इसका एग्जाम्पल क्या हो सकता है? Question with respect to reconsideration of question on jurisdiction in accordance with the provisions of chapter 4, or removal or rectification of any defect or any shortcoming in following the procedure which is prescribed for conduct of arbitral proceedings under chapter 5, or removal of any defects in the making of the award, or any shortcomings in the provisions with respect to the making of the arbitral award and termination of proceedings as contained in chapter 6 of the act. So ये कुछ ऐसे examples हैं जिनमें कि it would fall within the purview of a relook at the arbitral award, at the arbitral proceedings by the arbitral tribunal, right? Now, the resumed proceedings can only be related to the grounds raised in the application under section 34. You can't be resuming the proceedings with respect to all other grounds, all other things. If the arbitral tribunal says that, okay, we want to resume with respect to some other matters as well, you can't do that. You can't reopen the proceedings again, right? But only the proceedings with respect to the grounds which have been raised under section 34, right? So as a consequence of the resumed arbitral proceedings, it may become necessary to record fresh findings and to amend the award, right? So thereafter, the court would consider whether the grounds raised have been eliminated and whether the award is liable to be set aside on that ground or not. Right? So I hope we are clear about this aspect. Let's proceed further to subsection 5, which talks about giving of a prior notice to the other party for complying for in order to comply with the requirement under subsection 5. uh, the application shall be filed by a party only after issuing a prior notice to the other party. What would be the notice regarding the same? That an application is being filed under section 34. So prior notice needs to be given to the opposite party with respect to the same, and an affidavit needs to be attached with the application for setting aside the arbitral award. Affidavit to what effect? Affidavit to the effect that a prior notice has been served on the opposite party with respect to initiation of the application for setting aside the arbitral award. And there's a time limit which is prescribed under subsection 6 of section 34, and it talks about the application to be disposed of as expeditiously as possible and in any event within a period of 1 year. 1 year from the date on which the notice as referred under subsection 5 is served. So, जब notice on the opposite party is served from the date of service of notice on the opposite party, क्या है कि the proceedings need to be disposed of by the court concerned. So, this is the law pertaining to section 34. I hope that the foregoing discussion has helped you in understanding the provisions pertaining to section 34 a little more than earlier. Now let's come to chapter 8, which is finality and enforcement of arbitral awards. Section 34 of the Act dealt with setting aside of the arbitral award. Now the next question that we need to assess is with respect to the award being final and binding on the parties. Section 35 contains a clear provision pertaining to the same, and it talks about the finality of an arbitral award, right? The language used in section 35 is very clear in its ambit when it talks about the finality of the final nature of the arbitral award and the fact that it is binding. Section 35 says, subject to this part, an arbitral award shall be final and binding on the parties and persons claiming under them respectively. Right? So the award is final and binding on the parties as well as the persons claiming under them. Now, the award of an arbitral tribunal is ordinarily final and conclusive unless the contrary intention can be inferred from the agreement itself. Right? So, an arbitrator has the power to do what the court could have done if the matter had been before the court. Right? His award puts an end to the proceedings. The court will not interfere with the findings of the arbitrator, even if the court feels on merit that the arbitrator should have come to a different conclusion, right? Because his award on both facts and the law is final. There is no appeal from his verdict. You cannot say that, okay, we can open the merits of the case and look into the conclusion drawn by the arbitrator. No, that cannot be done because time and again the courts have also supported this view. Right? The court cannot review his award and correct any mistake in his adjudication unless an objection to the validity of the award is apparent on the face of it, which of course we have discussed in our earlier discussion on section 34. So section 35 expressly declares that an award shall be final and binding on the parties and persons claiming under them respectively. Right? Also, section 36 of the Arbitration and Conciliation Act provides for the law pertaining to enforcement, right? How can the award be enforced? right? Now, in the case, before we discuss the provision, in the case of Union of India versus Bungo Steel Furniture Private Limited, the Honorable Supreme Court in the year 1967, going back to 67, because this expression, the language of the judgment is extremely important for us to note. So in this case, the Honorable Judge Ramaswamy had quoted a specific paragraph from an English judgment, which was of Hodgkinson versus Furnick. In this judgment, the Justice William had observed, and in Union of India, this has been quoted. And I quote, "The law has for many years been settled and remains so at this day that where a cause or matters in difference are referred to an arbitrator, whether a lawyer or layman, he is constituted the sole and final judge of all questions, both of law and of fact. The only exceptions to that rule are cases where the award is result of corruption or fraud. So the court has no jurisdiction to investigate into the merits of the case and to examine the documentary and the oral evidence for the purpose of finding out whether or not the arbitrator had committed an error of law. So, subject to the remedies which are provided in the Act, we understand the award cannot be set aside, amended, modified, or affected in any way whatsoever. But please note that I'm using the expression subject to the remedies provided in the Act, which means that Section 34 की जो grounds हैं, वो lie करते हैं. But other than those grounds, there is no other way that you can challenge the arbitral award if those grounds do not exist. Right. So this is with respect to Section 35. Let's come to Section 36, which talks about enforcement. Please note that Section 36 talks about direct enforcement of awards without having to get them converted into the rule of the court, right? Now let's see what Section 36 says. When does an award become enforceable? An award becomes enforceable as per Section 36 when the time for filing the application to set aside the award has expired, which means that the limitation period prescribed under Section 34 has expired, and now once it has expired, अब इसके बाद तो कोई भी challenge कर ही नहीं सकता उस award को, so that means that now it can be enforced, right? Now the question comes that the next question that comes is that how it is to be enforced. Once we know that when it can be enforced, we need to understand. Once we understand when it can be enforced, the next question is how it can be enforced, right? Now, in accordance with the provisions of CPC, in the same manner as if it were a decree of the civil court. So we understand that the law has tried to provide strength to arbitral proceedings by making an arbitral award, giving the arbitral award the status of a decree of a court, right? Which means that the same procedure that would apply in execution of a decree would also apply in the enforcement of an arbitral award. So all the detailed provisions, all the strength that is provided by the CPC in executing a decree would be used in case of execution of an arbitral award as well, right? Now, application for stay of operation of award is one very important provision that we need to look into, which has also been, brought about. The change has been brought about by the Amendment Act of 2015. पहले क्या होता था कि बेटा जब कोई application for setting aside of an arbitral award under Section 34 file होती थी, it used to operate as an automatic stay of operation of the award, right? So a separate application for stay of operation of the award needed not to be filed in that case, right? स्टे ऑफ ऑपरेशन की जरूरत क्यों होती है? क्योंकि हम जानते हैं कि जब इस अवार्ड को हम चैलेंज कर रहे हैं, ठीक है, तो अगर वो उसको हम जो है अगर इसको ये चैलेंज किया हुआ है, देन इन दैट केस द अवार्ड की जो ऑपरेशन है उसको स्टॉप करवाना जरूरी है ताकि till the pendency of that matter under Section 34, right? तो पहले जब भी फाइल होती थी एप्लीकेशन अंडर सेक्शन 34, it would operate as an automatic stay of the operation. But now under Section 36, the law that has been incorporated is as a result of the 2015 amendment is that when an application to set aside the arbitral award has been filed in the court under section 34, the filing of such application shall not itself render that award unenforceable. तो एक automatic stay जो है वो अब नहीं होती 2015 amendment के बाद में, unless the court grants an order of stay of operation of the said award in accordance with the provisions of subsection 3 on a separate application made for that purpose. So एक separate application जो है वो बनानी जरूरी है in such a case, वो along with the application for setting aside of the arbitral award under section 34, it needs to be, another application needs to be filed, which is application for stay of operation of the award. And if the court is satisfied that such a stay needs to be granted, then the court would grant such a stay and hence the stay would be operative, right? In addition to this, subsection 3 says that upon filing an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such conditions as it may deem fit, grant stay of the operation of such award for reasons to be recorded in writing, provided that the court shall, while considering the application for grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of a money decree under the provisions of Code of Civil Procedure. Now, the question that arises is that having due regard to the provisions of grant of stay of money decree under the CPC, इसका मतलब कि CPC की provisions को हम यहाँ पे apply कर रहे हैं, right? So, question came up for consideration in PAM Developments Private Limited. PAM Developments Private Limited versus State of West Bengal. The question as to the interpretation of the expression have due regard to the provisions proviso to subsection 3 में जो expression use किया गया है कि while considering the application for grant of stay in case of an arbitral award for payment of money, the court shall have due regard to the provisions for grant of stay of a money decree. The court was dealing with the question as to whether this would be mandatory requirement, right? In PAM Developments Private Limited versus State of West Bengal in the year 2019, the Honorable Supreme Court, while granting stay to enforcement of award, held that the provisions of CPC dealing with stay to money decree have to be considered, or in other words, to be taken as guidelines, right? It is not mandatory to follow them. So they may be considered, they may be taken as guidelines, but it is not mandatory to exactly follow them, right? So this is the law as contained in section 36 pertaining to enforcement of an award. And the last topic of discussion is with respect to appeals. Now, there are certain appeals which can be filed against certain orders passed by courts or by arbitral tribunal. And where the appeal would lie, that's again provided in this table. So for ease of understanding, I've prepared this table for you. Now, as per the law contained in section 37, appeals can be filed from the orders of courts to the court authorized by law to hear appeals from original decree of the court passing the orders. इस कोर्ट के ऑर्डर के खिलाफ जिस कोर्ट के पास पावर है टू हियर अपील्स फ्रॉम द ओरिजिनल डिक्रीज ऑफ दिस कोर्ट, ठीक है? तो इस ऑर्डर के खिलाफ उस कोर्ट में जाएगी अपील. And from the orders of the arbitral tribunal कहाँ जाएगी अपील? To the court as provided under section 2E of the act. ठीक है बेटा? So ये तो हो गया जो हमारा technical requirement है to assess as to from which court's orders or from which forum's orders the appeal will lie to which forum. I will repeat that for you. Appeal from the orders of courts which are made under section 8 of the act, section 9 of the act, section 34 of the act. इन ऑर्डर्स के खिलाफ अपील फाइल हो सकती है. यस, अपील फाइल हो सकती है. कौन सी कोर्ट में फाइल होगी? जिस कोर्ट के पास पावर है टू हियर अपील्स अंडर द लॉ फॉर द टाइम बीइंग एनफोर्स्ड from original decrees of this court. Say for example, this court which passed the decree, this court which passed the order was a district court. So the court which is authorized to hear appeals from original decrees of district court is the high court. So high court के पास अपील जाएगी यहाँ पे, ठीक है. और अगर it is an order of arbitral tribunal, right, then in that case arbitral tribunal के order के खिलाफ कोर्ट के पास डिक्री कोर्ट के पास जाएगी अपील, जो कि कोर्ट as per 2E है, which is either the district court or the high court having jurisdiction to deal with that matter, right. Had that matter been a matter of a civil proceeding, had arbitration not been conducted, तो जिस कोर्ट की jurisdiction होनी थी उस मैटर के साथ डील करने की, तो उस कोर्ट के पास जाएगा. तो बेटा कौन से ऑर्डर्स से अब अपील फाइल हो सकती है? पहला तो रिफ्यूजिंग टू रेफर द पार्टीज टू आर्बिट्रेशन. सो सेक्शन 8 टॉक्स अबाउट रेफरिंग द पार्टीज टू आर्बिट्रेशन. अगर रिफ्यूज कर देती है कोर्ट, अगर तो कोर्ट ने रेफर कर दिया फिर तो कोई प्रॉब्लम नहीं है, बट अगर रिफ्यूज कर देती है रेफर करने के लिए तो उसकी ऑर्डर के खिलाफ अपील फाइल हो सकती है. यस. और ग्रांटिंग और रिफ्यूजिंग टू ग्रांट एनी मेजर्स. सो कोर्ट के पास पावर है इंटरिम मेजर्स ग्रांट करने की अंडर सेक्शन 9 before, during or after the arbitral award is passed, before the arbitral proceedings, during the arbitral proceedings or after the arbitral award is passed, but before its enforcement. But जो during वाला aspect है, it is covered under section 17 कि अगर arbitral tribunal है तो वो जो है इंटरिम मेजर उसके पास पावर है पास करने की, इंटरिम मेजर लेने की, unless it is found that such a remedy under before the arbitral tribunal would be inefficacious, है ना. तब section 9 के अंडर during arbitral proceedings भी जाया जा सकता है for an interim measure during the pendency, ठीक है. And third type of order against which an appeal can be filed is the order setting aside or refusing to set aside. तो दोनों तरह से, अगर तो set aside हो जाता है award, उसके खिलाफ अपील फाइल हो सकती है. अगर set aside नहीं होता है, there is a refusal to set aside, then also appeal can be filed, right. And with respect to orders of arbitral tribunal, there are two types of orders against which appeal can be filed. One is accepting plea for challenging jurisdiction of arbitral tribunal. So अगर कोई jurisdiction of arbitral tribunal is challenged under section 16, right, for challenging the jurisdiction, section 16 के अंडर चैलेंज होता है, तो section 16 के अंडर दो कोर्सेज फॉलो होते हैं. एक तो आप अगर रिजेक्ट कर देते हो या आप एक्सेप्ट करते हो. अगर रिजेक्ट करते हो तो आर्बिट्रल प्रोसीडिंग्स जो है कंटिन्यू होती हैं एंड एक अवार्ड पास हो जाता है. दैट अवार्ड कैन बी चैलेंज्ड अंडर सेक्शन 34. This is the procedure that we follow in case of rejection. But in case of acceptance, the arbitral tribunal accepts the plea for challenging. Then against this acceptance, appeal can be filed before the court under section 37. ठीक है बेटा. And the second order which can be challenged is of granting or refusing to grant an interim measure under section 17, right. So अगर interim measure grant किया गया है या refuse किया गया है, उसके खिलाफ भी जो अपील है वो कोर्ट के पास जाएगी. Raising questions regarding interference of the courts in arbitral matters. Another question that needs to be assessed is that at this stage, can new points be added? Can new questions be raised? Can new issues be cited? Now, an application for incorporation of additional grounds in application under section 34 की भी अगर हम बात करें या appeal under section 37, मेमो ऑफ अपील कहते हैं बेटा इसको, है ना. तो मेमो ऑफ अपील अंडर सेक्शन 37 में अगर हम नया कोई पॉइंट ऐड करना चाहते हैं, an absolutely new ground for which no foundation had been laid in the application for setting aside the award, it would be rejected in that case. You cannot do the same. Now, this law has been laid down by the Supreme Court in the Honorable Supreme Court in the case of State of Maharashtra versus Hindustan Construction Company Limited. State of Maharashtra versus Hindustan Construction Company Limited. in the year 2010. The Honorable Supreme Court has held that in case there is an absolutely new ground which is sought to be added in the memo of appeal under Section 37 and for which no foundation has been laid in the application for setting aside the arbitral award, it would be rightly rejected, right? So this is the law pertaining to the same, and also subsection 2 of subsection 3 of section 37 says that no second appeal shall lie from an order passed in appeal under this section, but nothing in this section shall affect or take away any right to appeal to the Supreme Court. That's the last subsection as far as this provision is concerned. So yes, we do understand that it bars a second appeal, but the Honorable Supreme Court has held in a case which is ITI Limited versus Siemens Public Communications Network Limited. ITI versus Siemens Public Communications Network Limited, 2002. Now, in this judgment, the Supreme Court has held that an order passed by a civil court in an appeal under Section 37 is revisable by the High Court under Section 115 of the CPC. So revision जो है वो हो सकती है. It certainly bars a second appeal, but not a revision. Revision is not barred. So revisional jurisdiction of the Honorable High Court will lie in such a case, and the applicability of the CPC has also not been expressly prohibited. So the court in this case said that the application of the code Code of Civil Procedure cannot be ruled out on the basis of an inference. It cannot be said that a revision under Section 115 would be a judicial interference in the process of arbitration of such a nature as is contemplated by Section 5 of the Act. So this is with respect to the revisional jurisdiction. So the provisions of subsection 3 do not override the provisions of Article 133 of the Constitution, and we do understand that an appeal will lie to the Supreme Court if the provisions of Article 133 are otherwise complied with, right? So this is the law pertaining to the setting aside of the arbitral award, the finality of the same, its enforcement, and appealable orders. Thank you.